Hey, my name is Ben Freer, and the topic of this video is the E-2 visa versus change of status. So this is a topic that's coming up over and over again in my practice, so I figured that I'd make this video about it. If you are someone who's interested in the E-2 visa and you think that you could probably qualify based on your nationality and the investment that you plan on making, then you've probably started to look into the application process. And when you look at the application process, you will realize that there are a few different ways that you can apply for the E-2. You can apply for E-2 status via a change of status while you're physically present in the United States in a different visa category, or you could apply for the E-2 visa through an embassy or a consulate abroad. A lot of people assume that there's not much difference between these two options, which is completely understandable. After all, both applications are made through the US government, so you would assume that the benefits of each option are similar. However, there's a huge difference between the benefits of an E-2 visa and E-2 status that you get after applying for a change of status. So here's what you need to know about the E-2 visa versus change of status. So let's first talk about applying for a change of status. You can apply for a change of status by filing Form I-129, the E-supplement, and supporting documentation with USCIS. And if you pay for premium processing, you can get a decision on that application within 15 days. Now, before you select this option of applying for a change of status, make sure that you talk to an immigration lawyer, because there are some risks associated with this path that could create major problems down the road. Okay, so let's fast forward. Let's assume that you talk to an immigration lawyer. You decide that a change of status would be a good idea for you. So you make the application and you are approved, and that's fantastic. Now that you have E-2 status, you can actively manage your business in the United States. And you will have that status for 2 years. So during the next 2 years, you can stay in the United States, you can grow your business, your spouse can apply for work authorization, and all of that is great. However, there's a huge catch, and that catch is you do not actually have a visa. That means that you cannot typically leave the United States and then re-enter on E-2 status unless you first make another separate application through a US consulate or embassy to actually get the E-2 visa. Now, this is kind of difficult to explain, and I'm not sure that I'm doing a great job of explaining it. So let's look at some of the information that the US government has put out about this topic. Here is some language from the FAQ section on the website for the US Embassy in Toronto. So here's the FAQ. I received a change of status from the US Citizenship and Immigration Service. Is that all I need in order to receive an e-visa at your office? And here is the response. No. Investors who have changed status in the United States with USCIS must follow the steps for all first-time investors. Such a change of status remains valid only while the applicant remains in the United States. Once the applicant has left the United States, he or she requires an e-visa to return and resume the running of his or her business. Change of status does not guarantee the issuance of a visa, nor does it exempt the investor from the normal process of filing documents in advance with the US Consulates General in Toronto or Vancouver. So that sounds like a major hassle, right? You're probably wondering, why would anyone apply for a change of status? While applying for a change of status is not typically ideal, there are some compelling reasons to do so. For example, if interviews are not available, you may want to consider a change of status. So as I'm recording this, we're coming out of a pandemic. A lot of the consulates around the world are still not scheduling non-immigrant visa interviews. So if this is your situation, then it may be worth looking into change of status as an option. Another reason why you may want to consider change of status is if you're home consulate or embassy denies a lot of cases. If the embassy or consulate abroad is difficult to deal with, then it may make sense to first get an approval under your belt, do the change of status first, get an approval from USCIS, and then you can at least point to that approval when you apply for the visa. Or maybe you cannot easily travel back to your home country. If it's difficult or impractical for you to return to your home country in order to attend an interview, then it may make sense to consider a change of status. And finally, if you've already set up your business and you need to run it as soon as possible, then it could make sense to apply for a change of status, because you can apply for premium processing, which would get you a decision in 15 days. So those are some of the compelling reasons why you may want to apply for a change of status. But most of my clients plan on traveling internationally fairly frequently, and they don't want to make a second application for the visa, so they typically prefer to avoid the change of status route as long as interviews are available abroad. So let's chat briefly about the mechanics of applying for an E-2 visa. To apply for the E-2 visa through a consulate or embassy abroad, you will file DS-160, DS-156E, along with supporting documentation. You will submit all of this information according to the post's specific instructions. You will then attend an interview, and after a successful interview, you will receive the visa that enables you to enter the US during the period of time that the visa is valid. The length of the visa validity will depend on the country that you are from. So to learn about the length of the E-2 visa for your particular country, take a look at the visa reciprocity section on the Department of State website. Once you have the visa, you'll be able to travel in and out of the United States. And for each entry into the US, while the visa is valid, you will get 2 full years of status. So let's say you have a 4 or a 5 year visa, which is fairly standard. You enter the United States and you get 2 years of status. So the question is, do you have to apply for extension at the end of the 2 years? You could, but I wouldn't, as long as your visa is still valid. Instead, I would simply leave the United States before the end of the 2 year period, knowing that when I re-enter, I will receive a fresh 2 years of status. So there you have it. In my opinion, applying through a US embassy or consulate abroad is better because it gives you greater flexibility to travel internationally, and it prevents you from having to make another separate application for a visa before entering an E-2 status. I hope all this makes sense. Before you decide on the E-2 visa path, please reach out to one of the many amazing immigration lawyers that we have throughout this country. They would be happy to provide you with some guidance, explain this concept further, and explain other aspects of the E-2 visa. If you did enjoy this video, please like it or pass it along to someone who could benefit from it. Thanks so much for watching.